In the Superior Court of Cobb County, State of Georgia, Civil File Action 23-1-08556, available in public record for you to download right now. If you don't believe what I'm about to go through, I'm about to go in detail and I'm about to tell you everything about the plaintiff, Benjamin C. Armstrong, versus Carlos Diaz, Timothy Shedd Jr., Timothy Shedd Sr., Justin Williams, Allison Five-Ash, and Nicholas DeMondi defendants. This is the plaintiff's emergency motion for a preliminary injunction against the defendants and the appointment of a receiver before the Honorable Judge Kimberly A. Childs, Superior Court, Cobb Judicial Circuit. This is on February 16th of 2024. Appearances on this are going to be Stacey Godfrey Evans, Tiffany Watkins, and Michael Lambros. That's the attorneys for Ben. Daniel C. Norris for the defendants, Tim and Tim Jr., Tim Sr., Tim Jr., Nick DeMondi, and Justin Williams. Stephen Yacklin for Carlos Diaz. Owen Ferrist for Allison Five-Ash. And then George Koenig, who represents BJ Investments, Hit Networks, LLC, High Throughput Production, TJSJ Holdings, LLC, and REBJ, LLC. So grab yourself some popcorn because this is about to get wild. I'm going to take you through this. If you like this type of content, by the way, make sure you hit the like button, subscribe button, the bell to be notified, and share this with as many people as possible. This is about to get wild. Now, I've been through this. This document is 244 pages long of testimony. This is testimony. I'm going to be telling you exactly what TJ, Lady Frame, you might call him, Junior, you might call him, Timothy Jackson Jenkins Jones, whatever his name is. But you guys, this is going to be unbelievable. And I hope and I pray that you guys are listening and paying attention to this because this is going to be absolutely wild. I'm going to pull this up for you right now so you can see it. This is in the Superior Court of Cobb County, State of Georgia, Civil File 23-1-08556. Now, I'm going to scroll down here just a little bit. I'm going to keep you guys live here. We're just going to do this. We're going to raw dog it, if you will. And this is basically some information about who's representing who, what people are doing, et cetera, et cetera. We're going to skip through the preliminaries. The whole purpose here is that Ben wants this company put into receivership. That's already been approved. So now we're going to get to, I think it's page 33, where we're going to get Tim under oath. Okay. This is a statement, however, that we should do. Okay. This is Mrs. Evans. This is Ben's attorney. History has shown us in this case that the defendants have a tendency to bring extraneous information to the tables. And if they do, then I needed to be prepared to rebuke that. And that's the reason we have the subpoenas. But again, thank you for your time. It may please the court. I believe the court is somewhat familiar with this, with the parties having so many cases in front of your honor. But just very briefly on the facts here. My client, Mr. Armstrong, Mr. Benjamin Armstrong, is the talent and brainchild behind BitBoy Crypto YouTube channel, which grew exponentially over the last few years before Mr. Shedd, who is one of the defendants, became involved. At Mr. Armstrong's invitation, the company and the YouTube channel had a $7 million value and over 600,000 subscribers. This is when they first got together. Mr. Armstrong is very popular in this space, and the fact that he was able to garner a $15 million 15-month sponsorship deal is just one example of that popularity. And the fact that when Mr. Armstrong was improperly ousted from the company, which is our allegation, that sponsorship went away immediately. I mean, he is the talent, he is the brains, this is his company, and despite the wrongful ouster, he is still the majority owner at 67%. So we're here today seeking a receivership over the companies and the properties at issue in the litigation. And it gets a little confusing because there are a lot of entities. So I've made a chart, and I don't intend for this to be an exhibit, but just a demonstrative tool if I may approach the bench. So she then gives the information so that they have it. There's no protestation. There's nobody. There's no real protests or anything like that that happen. Okay. So then, as we go, so the companies at issue that we are seeking receivership on the back, you will see information about the real estate holdings, which is REBJC LLC, That is also the issuer, but a little bit separate from the entities that are on the front. All of these entities in their various forms are 67% Mr. Armstrong, 33% Mr. Shed at the end of the day when you boil it all down. Now, we are here again for a receivership under 981, which provides that when a fund or property is in litigation and the rights of either or both parties cannot otherwise be fully protected, a receiver may be appointed. And this is completely in your honor's discretion, will not be interfered with on appeal unless there is a manifest abuse of that discretion. Now, here with the various litigations that is before your honor, the parties dispute who ousted who first. Mr. Armstrong was the majority owner, had the right at any point to make decisions with a 67% ownership interest, with a 67% vote to tell people to leave, to let people stay, all of those things where he was in charge. He told Mr. Shed, you are out. This is not workable anymore. You are not doing what I hired you to do, which was to do the operations. Mr. Armstrong was the talent, the creative voice. Mr. Shed was supposed to do the finances and keep the operations. And in Mr. Armstrong's opinion, he wasn't doing that. And he said, we're done. Well, Mr. Shed, of course, did not like that and went and lawyered up and wrote a letter claiming to oust Mr. Armstrong for alleged misconduct. Now, that's the dispute. That's what the litigation is going to decide. But we need to make sure at the end of that litigation that there's something left, because maybe they are right. Maybe we are right. We can't decide that today. And if you assume that the ouster of Mr. Armstrong was effective, and we believe it was not because Mr. Armstrong told Mr. Shed to leave first, but even if you assumed it was right, you can't erase his ownership. You don't just kick someone out and take their property. That's not how America works, with all due respect. And in the letter that they submitted, which we will put into evidence today, the letter that they gave purportedly ousting Mr. Armstrong acknowledged this interest. You have an ownership interest. We are going to get an appraisal. We are going to buy you out. All of that was supposed to take place within 60 days of the letter, which was August of last year. No appraisal, no buyout. They just changed the locks, changed the passwords, locked him out. Essentially, they got to a locksmith first. They engaged in self-help, and they decided the outcome of this case before this litigation even got started. Mr. Shed made himself the judge and jury on whether Mr. Armstrong has even done the things that under the operating agreement may have possibly given him the right to oust him. Those are things that the court has to decide. And in the meantime, Mr. Armstrong has no sight into the bank records, even his simple request for transparency into the books and records to date. As a 67% owner, even if you assume that under the ouster he has no management rights, he is still the majority owner of all property interest. They won't even let him see the books. They won't let him see any records. We don't know where the money is going. Is the company paying for all of the legal fees for this side of the room, but not this other side of the room? They're definitely not paying my fees. Mr. Armstrong is having to pay all of this personally, while Mr. Shed has just taken the company. In the meantime, the promise for the buyout offer required are ignored. Taxes are unpaid. Taxes are unfilled. The company's main deal that it had, $1 million a month, gone. As soon as Mr. Armstrong left, the company said, talent is gone. My sponsorship dollars are gone. Millions of dollars, which will show in an affidavit, are being transferred to unknown sources to pay who knows what. Mr. Armstrong hasn't received anything. If there are distributions made, he is still a 67% owner. He should be getting a distribution as well. We believe the evidence will show there are illegal transactions occurring during the operations right now. The company is bleeding cash. They've laid off over half of their employees. The employees that have stayed have agreed to take a 50% pay cut. Mr. Shed's lies and illegal activity. Let me say that one more time just so you guys hear it. Mr. Shed's lies and illegal activity, we believe, undermine his credibility to protect the company and certainly Mr. Armstrong's rights. Then with regard to the real estate, we will put into evidence listings that show motivated seller. We want to sell fast. They are dumping these assets and pocketing the money at the expense of the majority owner while still not offering an appraisal, still not offering him a buyout, which is required even under their theory. Now, with regard to the real estate company, specifically, the defendants are going to claim that Mr. Armstrong signed over his ownership rights in the real estate holding company, which had millions, multiple millions of dollars in real estate holdings. They are going to try to tell you, Your Honor, that Mr. Armstrong signed that over in a very questionable DocuSign document for $313,000. Now, he didn't do that. He didn't sign it. A lot of people had access to his passwords. We believe the evidence will show he didn't sign that, and it defies logic that anybody would sign over their rights to a 67% interest in a multiple million-dollar real estate holding company for $313,000. But even if this is going to be the defendant's theory about why that real estate company can't be subject to the receivership because they are going to claim, well, he signed everything over, there was no rights, he had no right to it, so it can't possibly be at issue in the litigation. But even if you assume this bizarre scenario that my client signed over a multi-million-dollar asset for $300,000, it's still subject to a receivership because this real estate company is indebted to the main BJ investment holdings for over $4 million. So when you have an OCGA 983 provides that an appointment of a receiver is proper to take possession and hold any assets charged with the payment of debts where there's a manifest danger of loss, the destruction of material injury to those interested. So this real estate holding company owes over $4 million to their own P&L, which we'll put into evidence. They owe that to the main company, BJ Investment Holding, that my client is a 67% owner in. So that's to give you kind of a summary and a breakdown of where we are. And now we're going to move forward because what we're interested in now is going to be some testimony. So now, without further ado, we're going to talk. Timmy Tam. Timmy Tam. I don't know what you would call him. Lady Frame. That was just my thing. But so here we have it. This is where it starts. There's a couple things here that we'll get into, but we're not going to. All they're saying is we're looking to receive. Mrs. Evans is saying we're looking to receive a receivership. There's a lot I could respond to, but I'll hold it for closing and would like to call Mr. Shed Jr. to the stand if it pleases the court. Mr. Shed is coming to the stand now. If you would raise your right hand, Timothy Shed Jr., have you been first duly sworn, was examined, and testified as follows? The witness says yes. The court says right. Before we get started, I just want to remind everyone that unless you are an officer of the court, a meaning of the member of the court staff, or an attorney, any electronic devices need to be powered off completely. Should I stand here? Miss Evans says. And we'll go through this real quickly here. Good morning, Mr. Shed. He says, good morning. Do you recall sending a letter to Mr. Armstrong purporting to oust him from the company that we are here to talk about today? Yes. And how did you initiate that letter? When you say initiate, the court, can you get closer to that microphone for me? The court says, thank you. Did you write it? Yeah, I met with counsel on preparing the letter. When did you meet with counsel? A variety of times in August. Starting when? I believe the first time I engaged him was after Mr. Armstrong had assaulted me in the office. I believe that was Monday, August 21, when he attacked me in the office and said he was going to kill me. Mrs. Evans says, may I approach, Your Honor? The court says yes, and if you will just walk around to hand it to him, and et cetera, et cetera. So what they're doing is they're handing over a document, okay? I think that's okay, but they are very Taco Mac-ish. It is. If you give me too many devices to play with, I'm certain I'll trip over myself. So we're just kind of working their way through it here. But yes, is this, Mr. Shed, is this the letter that you sent to Mr. Armstrong purporting to oust him from the companies? Yes, it looks like it. And do you recall when? Strike that. It's dated August 25, 2023. Do you see that? Yes. But when did you actually deliver this? When did I get it delivered? I believe it was the 27th that weekend. Sunday? Sunday? Okay, looking at, do you see the first page, number 5? Yes. The company hereby elects to purchase the ownership units comprising 670 ownership units and all of the ownership and membership interest in the company held by BTTJ. Do you see that? I do see that. And was it your intention? Is it still your intention to purchase Mr. Armstrong's interest in the company? Yes. Yeah, that was our intention was to fulfill the operating agreement, which Mr. Morris articulated. The buyout provision was in there. Do you have a letter indicating your choice or efforts to initiate an appraisal process within the court? Not with us in court, no, but as he mentioned, it has been sent to Mr. Armstrong in the past. Is it in writing? Yes. Has it ever been sent to me? I don't know. Has it? And now you're seeing him becoming a little bit of a jerk. This is Mr. Lady Frame Shed Jr., the Tim Teager, whatever. Has it ever been sent to Mr. Lambros to your knowledge? I'm not sure. Have you undertaken an appraisal of any of the companies at issue here today? The answer from TJ, I know Mr. Armstrong demanded we do not do that under any circumstance. He said it would. His claim was that it would be a waste of resources, and that is in writing. After you sent this letter, Exhibit 1, to Mr. Armstrong, did you change the locks to the physical location of the company? Yes. Or did you have them changed? The locks were updated, yeah, at the building. And when did that happen? I can't tell you the exact date. It would have been within a couple of weeks of his removal. And did you access Mr. Armstrong or have Mr. Armstrong's email accessed after he was ousted from the company? No, I did not. Your testimony under oath is that you have never changed those passwords. And then he says to Mr. Armstrong's personal email, no. To his email for the company? Are you saying his company email? Yes. Yes. His company email we have retained. Yes. And you have changed the password. Yes. Did you have or any did you have and or change Mr. Armstrong's password to the YouTube channel? Yes. How did you obtain Mr. Armstrong's passwords to change them? You were talking about his company emails we have within the admin portal for the company. We can do that. Did you get these from Miss Five Ash? No. Did you get any passwords from Miss Five Ash? No. If she were here to testify, she would say you never asked her for any passwords? I believe so. Prior to you sending Exhibit 1 to Mr. Armstrong, did he tell you that your business relationship between the two of you was over? TJ says, no. He said he would see me in the office or we would only be speaking under business terms. Okay. He never told you that it was over and that you were out and that you were not going to be part of the company anymore. Not exactly. No. Well, what about inexactly? And TJ says, he said that my only context for speaking to him were for business purposes only. Did he tell you that your business relationship between the two of you was over and that you were no longer going to be part of the company? Yes. After he threatened to kill me, he did say that. Did he tell you those words that I just said, word for word? Did he, Mr. Armstrong, indicate to you that you were no longer going to be part of the company? And this is an objection. The Mr. Norris says that this is a vague one. The court asks, why is it vague? And Mr. Norris says, part of the company. The court says, well, he can answer if he knows. Overruled. I'm not sure. I can't. And then Mrs. Evans says, your testimony under oath is that you are not sure if Mr. Armstrong told you that he is no longer wanted you, that he no longer wanted you to be part of his company, that y'all are not going to be in business going forward. He said that at some point in time. Yes. He said that prior to Exhibit 1, didn't he? And TJ says, I'm not sure. You are not sure. You never had a text exchange with him where that was also discussed that you two were not going to be in business going forward. In the text exchange I'm remembering is when he said to me that I can only talk to him for business purposes only. And so that to me implied that we were still going to be in business together. Did you ever have a conversation with him where you acknowledged that he had told you prior to Exhibit 1 that you were no longer going to be part of the company? Prior to Exhibit 1? No. Never. That's your testimony under oath here today. Can you repeat the question? Did you ever have a conversation with Mr. Armstrong where you acknowledged that he had told you prior to Exhibit 1, your letter attempting to oust him, that you were no longer going to be part of the company? Answer, Tim, under oath. No, I have not. Question, that never happened. No. Mrs. Evans says, may I approach? The court says yes, and all the lawyers leave to approach all the witnesses for the remainder of hearing. Thank you, Your Honor. Did you tender P1? No, Your Honor. Thank you. I would like to. Okay, any objections from this side? There's no objections. All right, admitted without objection. P1. Mr. Shedd, do you have Exhibit 2 in front of you? This is where we're going to find out that Teachers has a problem telling the truth is Rufus. All right, here we go. Mr. Shedd, do you have Exhibit 2 in front of you? Yes. Do you see the little, what do you call that at the top of the message in the circle? The icon? I don't know. Yeah, I see the icon. Yeah. Do you see where it says TJ? I do. Is that you? It is not. Who is it? It's a picture of a trash can. Oh, Ben Armstrong. Is TJ referencing you? I don't know. I assume so. Do you recognize this text exchange here that I've handed you in Exhibit 2? I do. Do you acknowledge to the court that you were part of this text exchange? Answer, it looks like just his text messages. Have you flipped to the second page yet? Oh, okay, yes. Mr. Shedd, for the record, do you acknowledge that you are a participant in the text stream reflected in Exhibit 2? Yes. And are you texting with Mr. Armstrong? Yes. And is he in blue and you are in black? Is that right? Yes. Do you see the text at the top of it? Sunday, August 20, 4:37 p.m. Yes. And that is Mr. Armstrong speaking. True? Yes, I believe so. Do you see the fifth line down where it starts, so I'll handle it? Yes. So I'll handle it, but you don't get to be part of it or anything I do going forward. Do you see that? Yes. Did you receive that on August 20 at 4:37 p.m.? Yes. So I'm going to ask, would you like to tender Exhibit 2? The court says, any objection? No objection. Admitted without objection. And the question is, did you have a conversation with Mr. Armstrong acknowledging that he told you that you were not going to be part of the company prior to Exhibit 1, your letter to him? No. I had a conversation where you can see at the text above where he's asking for a list of everybody who knows. What he's referring to is a list of everybody in the company who knows about his affair. Move to strike your honor as non-responsive. My question was, did you have a conversation with Mr. Armstrong where you acknowledged that he had told you that you were not going to be part of the company anymore prior to your letter, Exhibit 1? No, that never happened. No, I explained to you how the conversation happened, where he was, that what he was talking about handling was confronting each one of our employees about his affair. I'm not talking about text messages. I'm talking about a conversation, a verbal conversation. I know, a verbal conversation. I'm talking about what happened on Sunday, August 19, between the two text messages. Ms. Evans says, move to strike as non-responsive. Question, I'm going to ask about the conversation that I'm talking about. And I'm sure y'all had many conversations, right? I'm asking specifically, and I would like you to answer my question, and I've answered. Ask the court to instruct you. I've answered. Whether she will do it or not, did you or did you not have a conversation with Mr. Armstrong wherein you acknowledged that he told you that you were not going to be part of the company going forward prior to your letter? Exhibit 1, no. Never. Miss Evans says, Your Honor, I would like to play an audio clip, and I'm going to have to ask for Miss Watkins' assistance if that's okay. And the court says, let's take it put it to the Elmo until you're ready for today. If you're ready, let me know. So what they're doing right now is they're putting together this audio, okay? I have this on a flash drive. It's marked for exhibit, et cetera, et cetera, et cetera. Now, I don't purport to be a deposition of its recording of a telephone conversation as indicated on the front page, just to help everyone follow along with the recording. I'm going to play a clip from page 8, starting at line 5. I will represent that this is Mr. Shed speaking, and he will tell us later if it's not him. But that's why it says TJ, starting on line 5 of the written word of the conversation. So then the audio is played, and Miss Evans says, Mr. Shed, is that you? And he says, that is me. Do you deny anything that you said, anything that was just played? He says, I don't, Your Honor. I would now like to tender the conversation as Exhibit 3. Any objection to just the audio version? No, there's no objection to it. So it's admitted without projection. Mr. Shed, are you familiar with the finances of BJ Investment Holdings? Yes. Have you made, let me ask it in a different way, has BJ Investment Holdings made any payments to Mr. Armstrong since you sent the letter reflected in Exhibit 1? No. Has BJ Investment Holdings made transfers to you in any way since the letter reflected in Exhibit 1? Very little. I stopped taking payment around the same time. So I have taken, I think, about $15,000 since this whole thing started. And when we finally get access to the records of the company, it's going to show that no transfers to you or any other entities or any other individuals affiliated with you have received any transfers since Exhibit 1. Let's get ready for the shade. Mr. Norris says, objection. Ms. Evans says, other than the 1,500 or 15,000. Objection, too vague, compound. Let's just rephrase your question. When we finally get discovery and access to the financial records and books, your testimony under oath is that there will not be any reflection of payments to you personally, since the letter reflected in Exhibit 1, maybe 15,000. 1,500, 15,000 is what I said. 15,000 to the best of my knowledge, no, I would have to check. But will the books and records show payment to any of the attorneys present here on your behalf today since that letter reflected in Exhibit 1? Yes, some of the funds have been used for corporate counsel. Will the books and records reflect funds made on any homes that you live in or reside in since the letter reflected in Exhibit 1? Can you ask the question again? When we have access to the books and records that we have been deprived of thus far, will it show transfers to payments to pay for real estate that you own, reside in, or live in since the letter reflected in Exhibit 1? And the attorney says, Your Honor, I'm just going to note an objection to the characterization that they have been deprived of records. There's been no discovery in this case, and I have not been subpoenaed for any records that she is referring to. The witness says, again, I'm not sure which business and which books you are talking about, to be honest. Ms. Evans says, we will do it. We will take the time we need. Since the letter reflected in Exhibit 1, will the books and records of BJ Investment Holdings or High Throughput show a transfer of any funds to pay for any mortgage, rent, utilities of any real estate that you own, live in, or reside in since Exhibit 1? No. Where do you currently reside? Your Honor, I do have an objection to this particular question. Mr. Armstrong has been repeatedly discovered to be stalking my clients at their places of work and at personal properties that are owned by REBJ. Some of the tenants of those properties have been raising concerns about Mr. Shed about Mr. Armstrong appearance on the property. Has that been since counsel has been involved, since the original counsel, since his original counsel? Okay, I'm asking about his counsel because that's the one standing in front of me right now. Yes, she has been involved. The court says, all right, I will go ahead and say to everybody in this room, no more stalking or any type of behavior. In the event that I hear of some type of behavior like that or threatening or anything like that, I'll get you in real fast and we will deal with it accordingly. I will, at this point in time, I will sustain your objection because of this resident, since there's no allegation of violence. So getting back to it. Miss Evans says, Your Honor, can I, this is all far afield. It is, and I sustained your objection and I made my statement. This is the TJ's attorney arguing with the court at this point. Now, Miss Evans says the comments from counsel earlier that we are filing all these lawsuits. They filed 3. I mean, they're on social. They are on social media. We are on social media. I don't pretend that anybody is acting the way that they should. I just want to make that clear. But it's not. I didn't come here to talk about all of that because I don't think it's irrelevant. Because it's relevant. But I do want to acknowledge that it's not a one-way street, and I'm not going into it only because I don't believe it's relevant for the issues before you. Not because my client is not being mistreated, threatened. You know, threats made on social media. But we are here now. Yes. So we are all here and we've agreed. So now we get back to the questions. Mr. Shed, are you married? Yes. Has your spouse received any transfer of funds in any way, shape, or form from BJ Investment Holdings, Hit Network, or High Throughput Productions since your letter reflected in Exhibit 1? Yes. But she was fired. She didn't work there because they were having an affair. How much? I would have to check. Is that something that happens on a periodic basis? Yes. Not to you, but to her. Uh-huh. Are we seeing it now? So, do you have a joint checking account? No. Does she pay for finances of the joint household, car payments, house payments, things of that nature? No. Utilities? No. You keep completely separate finances? Yes. How do you feed yourselves? With my hands. But you haven't taken any money, according to you, from your company since August of 2023. Is that right? Other than 15,000. That's correct. Yeah, I have savings. So that's purely on savings. Yes. But your wife is taking money from the companies. Very little. Yes. But you can't tell me how much. Not off the top of my head. I would have to go check. Are you you are the tax officer for BJ Investment Holdings. True? No, false. Who is? The tax officer, CPA? Okay, well, let me ask you. I think I can go through the operating agreement and prove it, but we don't need to. Are you responsible for filing taxes for BJ Investment Holdings? We have a CPA that filed the taxes. Are you responsible for initiating that process? Yes. Has that happened for 2022? Yes. When? When did the process start? Did you file taxes? Did BJ Investment Holdings file taxes for 2022? No, they have not been filed. So let's go back here. Are you responsible? We have a CPA. Are you responsible for initiating the process? Yes. Has that happened for 2022? Yes. Did you file taxes? No. Have you filed for 2021? We are in very close to getting it filed for 2021. It was almost done, and then Mr. Armstrong put a stop to it through his CPA company that he had directed us to use in the past. And when do you say this happened, that he put a stop to something related to taxes that you were in charge of? He was very clear he was in charge of it, and that was around August or September of 2023. Well, what have you done since August of 2023 to ensure that the taxes for 2021 were filed? We've done everything we could to collect all of the data and information from the previous CPA firm, and we have selected a new CPA firm, and then we have engaged them. They were attempting to use some of the work from the previous CPA firm, but they have been very slow or unresponsive in delivering any of that information, so it looks like they are going to be redoing a lot of the work. Nothing has been filed for 2022. I just want to make sure that's correct. Have any tax deposits been made for 2021? For 2021, yes. I would have to check. What about 2022? I don't believe so. None? I don't believe so. Are you familiar with what's referred to as the stake deal? Yes. That was an advertising deal for the BitBoy YouTube channel. Yes. 1 million a month. Yes. 15 million total. Yes. Have you received, let me ask in a different way, has BJ Investment Holdings or the HIT Networks or High Throughput received any payment from stake deal since Mr. Armstrong was removed? No. How many employees approximately did BJ Investment Holdings, HIT Network, or High Throughput Production have at the time of Exhibit 1? I would say approximately 35 or 40. And how many does it have today? Approximately 20. And I would have to check. I don't know exactly. Guys, the person in charge of the company doesn't know the particulars about what they're in charge of. Just let that sink in for a second. Approximately 20. I would have to check. I don't know exactly. Then what the fuck is approximately 20? The employees that are currently still working with the companies, did they receive pay cuts? No, many of them didn't. Did any of them? Yes, some of them, yeah. How many did and how many didn't? I would say a small group did, most didn't. A small group meaning what? Maybe 15 or 20%. What kind of pay cut did they get? It depends on the employees. 10%, 15%, 50%, more than that, some 10, some 20, like I said, it was a range. Some 50. I don't think there was anybody that had a 50% pay cut. I'm not sure. I would have to check. So you can't say definitively under oath that no one received a 50% pay cut, can you? Not off the top of my head. I mean, we were undergoing a lot of changes. I had to make a lot of cuts, and it was a lot of different adjustments. Well, that's a lot of money, isn't it? If someone took a 50% pay cut, don't you think you would remember if somebody had to undergo such a cut? And the witness says, yeah, I would have to go check. I mean, I can get the information for you. But you can't say for sure that it didn't happen. I can't say for sure that it did or did not happen. You can't say for sure that it did or did not happen. I cannot say for sure. Do you know someone named Nina Marinoff? Yes. Who is she? She's an editor for us. What does that mean? She edits videos. So if she said half the company was laid off, including my whole team, and those who stayed had to take a 50% pay cut, your testimony under oath would be that she's not telling us the truth. No, that's not what I'm saying. Did she tell you that? Unfortunately, you don't get to ask me the questions. Mr. Shed, I'm going to hand you what I'm marking as Exhibit 4. I'm not suggesting that you receive this text message, but do you recognize Miss Marinov's picture there in this little text message? Yeah, I guess. I'm sorry. Talking to the microphone, yes. All right. So Mr. Norris now objects. Says I object on hearsay grounds, and the question necessarily calls for speculation. But I'm going to right now. I don't think there's an objection. I will let her ask her questions. Mr. Shed, do you see where Ms. Marinoff is indicating that half the company was laid off and those who stayed had to take a 50% pay cut? Now I entertain your objection. Mr. Norris says, same objection, Your Honor. So it's not in evidence yet, and he's right on hearsay. So I would sustain that objection on that question. So Ms. Evans says, and I would only argue, Your Honor, that it impeaches his testimony that this person that he recognizes worked at the company and said this. And he can say that. He can tell me that he thinks she's wrong. I mean, that's really the whole point of the exhibit. Mr. Norris says, counsel knows you can't impeach a witness with unsworn hearsay evidence. I'm going to sustain the objection. Fair enough. So she asks, your testimony under oath, Mr. Shed, regardless of Exhibit 4, is that you don't believe over half of the company was laid off. I don't believe so. And you can't tell me whether anybody had to take a 50% pay cut. I would have to go check the records. Like I said, I was dealing with a lot of people, and we made a lot of adjustments fairly quickly. I don't want to say anything that would be inaccurate. And your testimony under oath is that, well, let me ask you this. Can you say for sure that everyone who did stay that did not receive a 50%? But can you tell me that for sure? Yes. Of the people that stayed, I mean, some of them didn't take a pay cut at all. I said that. Like who? Many of our employees. Who? Nick Valdez. I mean, basically our new host, Joshua Jake, Hannah Hughes, Drew Weeder. Crower says Drew, and they spell the last name. Could you spell those names? And then who was the last one you said? Kelly Kellum. Is that enough? Anybody else? That's the most I can think of off the top of my head. I didn't realize I was going to have to prepare a list. Yeah, you did. You're in court. Well, that's 6 out of, you said, approximately 20% of the employees that you have today that didn't take a 50% pay cut. No, they didn't take any pay cut at all. Well, that would mean, I'm not going to argue with you. You've named 6 people out of the company's 20 that you tell me still work there today, and you're telling me these individuals did not take a pay cut, a 50% pay cut. They didn't take any pay cut at all. So they didn't at all. They also didn't take a 50% pay cut. Right? No pay cut. Are you familiar with REBJ LLC? Yes. And what is that? It's an LLC, a holding company. It holds what? I believe it holds other LLCs, real estate essentially. LLCs with real estate in them. Yeah. Have you attempted to, let me ask you this, to your knowledge, has anybody attempted to sell off any real estate held by either any of the LLCs that were held by REBJ or that are held directly by REBJ since Exhibit 1? Objection, compound. Ms. Evans says it's not. I'll allow the question. Can you restate it? This is when I miss real-time reporting. Since Exhibit 1, are you aware of any real estate either held by individual LLCs, held within REBJ, or held directly by REBJ that have been listed for sale? No. None? No. Are you familiar with a property at 3084 Cobb Parkway? Yes. Are you familiar with 3156 North Cobb? Yes. I'm doing two at once. I'm going to write the numbers. Mr. Shed, I've handed you what I've marked as Exhibits 5 and 6. Do you recognize Exhibit 5 as the listing for 3084 Cobb Parkway? Yeah, it looks like it. Is 3084 Cobb Parkway part of an LLC held as part of REBJ LLC? Not as far as I know. That you don't have any information about that? No, I don't believe it is. Who owns 3084 Cobb Parkway? I believe it's in a special purpose LLC, 3084 Cobb Parkway LLC. And who owns that? I do. At any point, have you held that together with Mr. Armstrong? I believe there was a point in time we would have to go back and check the timeline. But yes, right? You did remember at some point in time, even if you can't remember. We would have to go back and check. You were telling me under oath that you can't tell me for sure whether there was a time that y'all owned this together. I would have to go back and check because the way this property was done, it was right of refusal that didn't get executed at the time of closing. There's a lot of details with that. Well, I'll call Mr. Armstrong to talk about that. Okay. Do you see under executive summary on the second page of Exhibit 5 on the second page? Do you see where it says sellers are motivated to sell? Give us a call and send us offers. Yes. Yes. Was that your idea to put that in there? No. Well, whose idea was it? I'm not sure. Are you motivated to sell this property? Sure. Have you received any offers? I'm not sure if I have one. I'm not sure if I have one at this time. Have you received any offers? I didn't ask if you have any at this time. Like a written offer? No. I'm sure there's been some interest. Some people that have called and expressed an interest, if that's what you're referring to. So no sales. No sales. If you could look up Exhibit 3156 North Cobb Parkway, do you see that? Is this a property held by an LLC that is held by REBJ? I don't believe so. I believe it's also not held by REBJ. At any point in time, has this one been jointly shared with Mr. Armstrong? And object to the form vague. Yeah, I would have to go check. Just like, I mean, it's the same lot as the previous one. They're adjoining lots. Flip to the second page, executive summary. Do you see where it says we are looking? Yes, we are looking to sell fast and motivated to sell. So send over offers. Was that your idea? No, it was not. Whose idea was it? I'm not sure. Have you received any offers on the property? No, I'm sorry, not that I'm aware of. When was it listed? I believe it was initially listed late in 2022, like in September. What about the property reflected in Exhibit 5? I believe the same thing. I mean, basically, it's two adjoining lots, so I believe they've always been listed together. Are you familiar with the finances of REBJ? Not really. No, I'm not the manager. Do you have a 50% ownership interest in the property? So the finances are something that are important to you, right? Sure. Have you ever seen any financial statements related to that company? Ever? I'm sure I have. Yeah. Are you aware that REBJ owes BJ Investment Holdings $4.834816.45 million? I'm not aware of that. No. You've never been aware of that? No. What is your job title if you have one for REBJ? Well, none. I'm not involved, but you are the co-owner. True? True. So responsible for finances? No. Responsible for the debts of the company as an owner? They're allowing it. He says, I'm not sure. I don't know. If REBJ makes a profit, do you get money? Yes. So if REBJ has debt, are you responsible for it? I would assume so. Do you know what a balance sheet is? Yes. You've seen one of those in your work before? Yes. Mr. Shed, I have handed you what I'm marking as Exhibit 7. Do you recognize this as a balance sheet for REBJ? Yes. Do you see on the second page where it says due to or from BJ Investment Holdings? Yes. What is the amount listed there? Mr. Norris says, Your Honor, I'm going to object to all this line of questioning on the grounds it lacks foundation. He's already testified he's not the manager of the company, is not responsible for preparing the financials, and hasn't seen them before today. Ms. Evans says he said he recognizes this as the balance sheet from REBJ. So the witness says it's also from December of 21. So Ms. Evans says, who cares? It's a really old balance sheet. Mr. Shed, yeah, please don't talk. Ask a few more questions with regard to the foundation before testifying. Ask him to testify about the contents. Mr. Shed, you recognize this a moment ago as a balance sheet from REBJ. True? Whatever the date of it is, you recognize that's what it is. I recognize that that's what it says at the top of the page. Do you have any reason to dispute that other than the fact that you are the one that handed it to me? No. I'll try not to take offense. And you just told us that you are responsible for the liabilities, the debts of REBJ LLC. True. I told you, yeah, I'm a 50% owner. Right. So if you share 50% of the profit, you share in 50% of the liabilities. True. As far as I know. So you have to have some awareness of those liabilities, right? Yeah. Could you tell me what it shows on the second page of this exhibit due to from BJ Investment Holdings? I don't think you've laid the proper document because there's an objection here. Mr. Shed, do you dispute that REBJ is indebted to BJ Holdings? I probably would, yes. Again, I will have to go check. I didn't realize I was going to be questioned on the whole financial history. You're in court. What did you think was going to happen? These fucking people, man. I was going to be questioned on the whole financial history. I wasn't prepared to go all over this. Who would know this? Who would know what are the debts that are owed by REBJ? Bo Mason was the manager of the company. Is Bo in here with us today? No. Did you tell him not to come? No. Did you talk to him about today's hearing at all? I mean, he knew it was happening. Ben sent him a bunch of threatening text messages. Moved to strike that as non-responsive. So do you have any of those text messages here with you today? I don't. So that's speculation. Who was the manager of REBJ in 2021? In 2021, I believe it was BJ Investment Holdings. I'm sorry, it was who? I believe it was BJ Investment Holdings in 2021. And who was in charge of operations of finance at BJ Investment Holdings? Both Ben and I. So you, both owners, correct? Ms. Evans, I would renew my question, Your Honor, about the line due to and from BJ Investment Holdings reflected on the balance sheet dated December 31, 2021. What is the answer to what? What is due to and from BJ Investment Holdings on page 2 of the exhibit in front of you? Mr. Norris says, I will repeat my objection on foundation. While she has established that BJ was the manager at the time, she hasn't established that this particular witness among the two owners who has any responsibility or knowledge for the document today. He said he recognized it as the balance sheet, and now we have established that he is in charge of the finances and operations for BJ Investment Holdings, which he has just said was the manager of this company in 2021, which is the date of the balance sheet. The court says, I'll allow it. So, Mr. Shed, what is the amount due to or from BJ Investment Holdings reflected on page 2? The top of the line of the second page? Yes. $4,834,815.45. I think you meant to say 16 cents. Is that right? Is that what it says? Yes. Do you recognize that as meaning that? Yes. Do you see total liabilities just under that, over 5 million? Yes. And the vast majority of what would be the BJ Investment Holdings debt listed above that line we just went through. True. Has that been paid to BJ Investments? I think much of it has, but again, this is a really old balance sheet, so I would have to look at much more current records. But you really have no idea, do you? I'm not the manager of the company. Are you familiar with Tornado Cash? I'm familiar with it. I've heard of it. What is it? It's an online software within the crypto space for mixing different crypto assets. Is it legal to transfer money to or from through Tornado Cash to your knowledge? Objection to the form. He's not an expert witness on what's legal or illegal with some third-party currency. The court says, I will allow her because she said to your knowledge, I will allow the question. The witness says, can you ask the question again? To your knowledge, is it legal to move money to, from, or through Tornado Cash in the United States of America? I'm not. In the United States, I don't believe it is, so I'm not sure. You don't believe it is? I'm not 100% sure. Has the company been sanctioned for money laundering? Objection calls for speculation. To your knowledge. I'll allow it. Overruled. Which company? Tornado Cash. I believe they have been sanctioned. You are regularly, I'll ask it a different way. Do you move cryptocurrency through the blockchain? Is that what it's called? Do we? Yeah, we send crypto transactions. You know how to initiate cryptocurrency transfers? True? True. You know how to receive cryptocurrency transfers? True? True. That all happens on the blockchain. True? Yes. You are familiar with that process? Yes. You are familiar that it is not okay to send money to, from, or through Tornado Cash on the blockchain? True? True. You can't do that. Well, you can do that, but to your point, they are under sanctions. Yes. It's not illegal, right? Are you asking? It's not legal, right? Are you asking me? Same objection about the legal. I'll withdraw it. I think I have what I need. Mr. Shed, are you aware of do you call them crypto wallets? Yes, I'm aware of crypto wallets. Are you aware of the crypto wallets associated with the BJ Investment Holdings, hit networks, or high throughput? Objection, vague, compound. Sorry, compound is my objection. Court says, I'm going to, for judicial economy, I'm going to allow it. Thank you, Your Honor. Yeah, I am familiar with what? The wallet address, specific names. Is that what you're asking? Are you aware that there are certain wallets associated with BJ Investment Holdings, hit networks, and high throughput? Yes. And you're familiar with those, like the addresses or you. I'm aware that there's wallets associated with the companies. Yes, of course. Correct. Could I tell you the address number off the top of my head? No. What was the last exhibit 6? 7. Uh, Mr. Shed, would you indulge me and let me know what exhibit number I put on the REBJ LLC balance sheet 7? All right, Your Honor, I would like to tender exhibit 7 into evidence. And then, of course, there's an objection, and objection overruled. This article is now in the record. Thank you, Your Honor. The court says we're going to need to take a quick comfort break for everybody. This is a very fast comfort break for everybody. So then they take a little bit of a recess here. So now, Mr. Shed, who has access to the crypto wallets of BJ Investment Holdings, Hit Networks, or High Throughput? At this point, I'm going to ask you to put on your Mickey Mouse ears because you're going to want to listen to some of this. Basically, myself and a couple of other employees of the company. Who are the other employees? Timothy Shed Sr., your father? Yeah. Who else? And I believe maybe Justin Williams might have access to some. I'm not sure. Justin Williams does not work for, has never worked for, and has never drawn payroll from any of these companies. He is on the crypto wallets for Hit Networks and Discover Crypto. What? So, guys, let's keep going. Anyone else? Not that I can think of. No, I mean, there may be a small login to a small account somewhere but nothing notable. Is it possible to move money to or from one of the crypto wallets for BJ Investment Holdings, Hit Network, or High Throughput Productions without you knowing about it? Without me knowing about it? Sure. What about without you or your father knowing about it? Unlikely, no. Sorry, I just realized I wrote on the exhibit I marked, so I'm moving the sticker over. Mr. Shed, I've handed you what I have marked as Exhibit 8. Do you recognize this as a document that shows crypto wallets? Is this like an interface platform that you're familiar with? No. You've never seen anything like this before? I have no idea what platform or interface this is. No. Have you ever seen anything that looks like this? This is a screenshot. I admit it's not, I didn't bring up the whole blockchain network here, but is this a screenshot that looks familiar to you in your experience of managing, moving money to or from crypto wallets? No. Well, we'll deal with that with another witness then if you want to do that for me. How do you access the blockchain to make crypto transfers or get receipts? Where do you go? Usually a crypto wallet. Where do you go? It's not in your pocket, right? Sometimes it's in your phone sometimes with your wallet. Do you have access? How do you access it? That's a wallet called MetaMask. There's a wallet called Exodus or Edge. How do you do it? I use a variety of all of those wallets. And when you want to use one of those, where do you go? Your phone or your computer. Is there a website? Walk me through it. It's like an app. Like MetaMask is an app. Do you have it on your phone? It's explaining right now how to do this. Are you familiar with the wallet ending in 709552? No. That doesn't sound familiar to you as a wallet associated with one of the companies we are here to talk about today? No, like I said, I don't have the serial numbers memorized. I didn't ask if you had them memorized. I'm asking if it sounds familiar. It doesn't. The document that I showed you, Exhibit 8, have you seen that before? I handed it to you here today. I think you only mean that I think I only what was emailed last night. The court says, you saw a copy of the document reflected in Exhibit 8 before you came in here today. True. Yes, I saw you guys sent it over yesterday. And did you make any observations about it? No, just not other than I didn't really know what it was. No idea? No. What it is, I want to step back for a minute to the taxes that you told me you had not filed for 2021 or 2022. How much is the tax liability estimated? I would have to go check on that number. I don't have it off the top of my head. Is it more than 5 million? I really don't know. I'd have to go check. Is it more than 1 million? I'd have to go check, but it could be. Can you give me a ballpark? I really can't. I didn't realize that's what this was going to be focused around. What about 2022? Can you give us an estimate? No, none. No. More than 5 million? Probably not. More than 1 million? I don't know. Probably so. I have no idea. No idea. You are the operations guy for the company that we are here to talk about today. Yes. Any idea about the tax liabilities for 2021 or 22? No. Who communicates with the CPA about the taxes? We have a bookkeeper and my dad does. Do you? Sometimes. Do you see the drafts of the tax returns or do you answer questions from the CPA about it? I have in the past. Yes. Doesn't know, but has. Doesn't know, but has. And when those tax amounts are due to be paid, are you going to have the responsibility of paying them? Is that true? Yes. So you are aware of the amount of taxes that are estimated to be owed for 21 and 22 for either year. 2021, there was an estimated amount that got disputed. Are you catching this? There was an estimated amount that got disputed, so it's having to be redone, and now we have to redo 21 to get a correct estimate for 2022. What was the disputed amount for 2021? I don't know. I'd have to go check. I'm not sure off the top of my head. Um, more than a million? I believe it was more than a million. Yes. More than 3 million? I'm not sure. I really don't know. Are you making plans to pay taxes? Absolutely. I paid taxes for 2021. How much money have you set aside on behalf of BJ Investment Holdings, Hit Network, or High Throughput in anticipation of tax liability for 2021 or 22? And he says, I'm doing everything I can to maintain as many assets as possible to pay taxes we owe. I'm doing everything I can to keep as many resources aside as possible. Have you made any estimates on the amount of money? And of course, there's objections to that. And they get overruled again. We need to set aside as much money as possible. Any ballpark figure that you can give me on what amount is 1 million, more than 1 million. Are you saying 1 million? I think we should set aside as many assets and resources as possibly can. You think it's more likely more than 1 million of tax liability? Yes, potentially. Yes. At the current time, does BJ Investment or Hit Network or High Throughput have sufficient funds to pay this? I'm not sure. I can't answer that. You don't know? No, we are getting the taxes redone. How could I know that? I'm asking based on the estimates of the information that you are aware of from the CPA. Or do you have sufficient funds for the estimate? I'm not sure. Were you aware that Mr. Armstrong, through his counsel, requested access to financial information related to the companies that we are here to talk about today? You mean in regards to other litigation? No. Listen carefully. Are you aware that Mr. Armstrong, through his counsel, has requested access to financial information, books and records, checking account information for the companies that we are here to talk about today? Yeah, I think that's part of the discovery process, right? Separate from the discovery, are you aware that the requests are being made? I guess not. No. Are you aware that Mr. Armstrong has asked for access to that financial information of the companies that we were here to talk about today? No. Have you ever instructed anyone not to provide access to books and records of the companies at issue here today that Mr. Armstrong has requested? No. So if anybody did that, they did it on their own. Mr. Koenig, objection, Your Honor. Counsel knows I'm the only one who responded on behalf of the company. Mr. Lambros reached out to me about 10 days ago. I responded. And so they go through the process here of trying to figure it out. Are you aware of the request that your attorney just referenced that he said Mr. Lambros reached out to him? I was listening to what he was saying before he said it here today. Did you have any idea that the exchange happened between counsel? I guess I thought it was part of the discovery process. I knew they were looking for that information as part of discovery, but I didn't know what was discovery and what wasn't, I guess. Did you instruct that Mr. Armstrong was not to get access to that information? And it's a sustained objection. Understood. I'm trying to avoid putting counsel on the stand to find out who has denied us access to this information, if it was his idea or if it was the counsel's idea. I think you've made your point. And Koenig says, it's mine. He is falling on his sword. Ms. Evans says, perfect. I don't think I need to tender that email. I think it's probably stipulated now that Mr. Armstrong has been denied access to books and records and financial information for the companies at issue here today. I think it would be tendered, Your Honor. It explains the legal basis for why he was denied. All right. So it says, will anybody object to me writing exhibit numbers on the bottom? So they do that. So Ms. Evans says, I will acknowledge for the record that professional courtesies have been extended on responses to formal discovery requests, but of course, it's my position that as a 67% owner, regardless of who ousted who first, we are here also entitled to look at records. And that is the basis that we have been denied, not through the discovery process. Mr. Koenig says, and we provided legal authority, Your Honor. The court reporter then goes through it. We've provided legal authority, including case law on that. Thank you. And then the court says, no, actually, it goes to the clerk here, and the clerk handles blah, 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 blah. And they get back to it here. Admitted without objection for this. Mr. Shedd, have you seen any affidavit executed by someone named Jake Tuzinski? Yeah, that was the guy who was sent over yesterday afternoon. Did you review that? I did briefly. Do you dispute any of the transfers that are discussed in that affidavit? Object to form, object to everything. They object to it, of course. She wants to drill down for more questions. Do you dispute that any of the transactions discussed by Mr. Tuzinski's affidavit occurred? I would like to review it because I'm not sure. Ms. Evans says, okay, and Your Honor, I know I'm getting close to the end of an hour and a half. There's a lot of things that I didn't really think would be so difficult to establish as a baseline, especially this, since he said that he reviewed it. So as hard as I'm trying to finish, I might need a little longer. The court's here, so the court's granting more time, okay? Now, Mr. Shedd, I've handed you what I've marked as Exhibit 10, which is the declaration that you or the affidavit that you said that you had reviewed prior to coming here today, along with a separate subset of a copy of the appendixes in color, because I realized that when Mr. Tuzinski signed, the graphics that were in the color became black and white, and I think that they were easier to read in color, though still very hard even with my reading glasses. Do you recognize this document, Mr. Shedd, as the one with the affidavit, Mr. Tuzinski, that you just testified that you had reviewed prior to coming here today? Yes. and take the time that you need. Do you dispute any of the transfers that are discussed in this affidavit actually having occurred? I want to clarify. I'm not asking you to adopt Mr. Taszewski's opinions. I'm just asking for, do you dispute any of the transactions? And then the attorney comes in and wants to object and says, I object to the question as compound, calls for speculation. Ms. Evans says he said he reviewed it. There are transactions listed as coming from the companies that we are here to talk about today. And I just want to know if he is disputing that any of those occurred. And the courts, they're arguing about it. So now a yes or no question, counsel. The question here comes up to that they're going to allow this line of questioning. So the witness says, yeah, I think I might be able to make it simpler because there's a lot in this document. Obviously, some of it is very erroneous. I have no idea what the transactions are. They don't relate to any of the business at all. But I think the core part you were trying to reference, I believe, is that in the 10 or 11 section, and basically we're just transfers within the intercompany transfers. So nothing actually left the company. It was a transfer of one company to a different company. Are you talking about 10, 11, 12 on page 4? Yes, I believe so. Again, these are also, he did test the thing that he didn't have time to check was, these addresses are like B521. So I'd have to go back and check to be sure which it is. But yes, explain to me. You said there's intercompany transfers. So tell me from where to where. To a wallet, from a wallet was held by Gemini Exchange account, a Gemini Exchange held by whom or what? For BJ Investment Holdings, from an account held by who? BJ Investment Holding. What's the purpose of the transfer from one account to another? One is an operating account where we can exchange accounts, is where we can sell it to dollars so we can continue with operating expenses. So that's where we would be transferring the money to sell crypto for operating expenses. And they go on for a while on this. And there's some words here about whether it's left the company or not. What was it spent on? And it was spent on payroll. And what else? I'm sure office rent, office supply, standard operating business expenses, but mostly it's going to the payroll. Mortgages, no. The rent on the building, that's it. Let the record reflect that there's an answer coming from counsel tables, which is entirely inappropriate, and it was audible. And that's some people for vulgarities and stuff like, typical hidden network stuff, I guess. I don't know. Any money spent from any of the companies here to talk about today since the Exhibit 1, August 2020, spent on mortgage? None. There are mortgages to be paid on the properties? Yes, there is. Yes, one mortgage. No mortgage has been paid since August of 2023. I don't understand your question. There are properties either held directly or indirectly through LLCs by REBJ LLC Proof. Yeah, it's a property, yeah, but that's only one, correct. And what is that? 3102 Cobb Parkway. And does 3102 Cobb Parkway have a mortgage? Yes, it does. Has that mortgage been paid since August? Yes, it has. Every month? Yes. Who paid it? REBJ. Okay, what about 313 Clubhouse? What about it? Does it own a property? Yes, it does. Does it have a mortgage? No, it does not. How is it free and clear? It is. What about 1173 Cool Springs? What about it? Does it have a property? I believe it does. Is the property mortgaged? It is not. It's held free and clear? It is. What about 3208 McKeever Woods Trail? Does it have a property? It sure does. Does it have a mortgage? It does not. It's held free and clear? It is. What about 3208 McKeever Woods? It's a home. Who lives there? Renters, tenants. Where does the rent money go? Into REBJ or into its own LLC? Yeah. What about the 1173 Cool Springs LLC, the property held by it? What is it used for? It's a rental home. It has tenants? Yes. Are the tenants also employees of the company we are here to talk about today? Yes. Do they pay rent? On which property? 1173 Cool Springs? No. They live there for free? Yes. Who lives there for free? Now, of course, this is a question where we really, the question of I'm going to skip who lives there. Mr. They are allowing this, but I'm not going to do that. But we're going to go with 1173. Who lives at 1173 Cool Springs for free? This comes back to, I think, something that was an objection. The court says, talk into the microphone, please. Myself and my wife. So you've been living in 1174 Cool Springs rent-free for how long? Well, the employee, she doesn't pay rent. I pay rent. You just told me that no one pays rent. You asked if any employee lives there that didn't pay rent, and the employee would be my wife. So I'm sorry, that's what I thought you were getting at. I don't have any real-time transcripts to look at, but I believe the question was, are there tenants? And I said, do they pay rent? And you said, no. You said, are there any tenants, employees? No, my question was this: are any of the tenants employees? So do you want to clarify? Do you want to change your answer? No. Are there any tenants, employees? Yes. And my wife lives there? Yes. And there's no mortgage on that property. I'm going to ask my first question that I asked about this property again. Okay. Are there tenants at 1173 Cool Springs? Yes. Do they pay rent? Yes. That's a different answer than you gave me before. That's the answer. Yes, they pay rent. Yes. How much do they pay? I'd have to go check. It's your wife. You don't know how much she pays. I would be the one doing it, and I don't know off the top of my head. No. So you do it, and you don't have any idea how much you pay every month. No, I don't. Who lives at 3208? Guys, I don't know how much rent I pay. That's who lives at 3208 McKeever Woods Trail? Tenants. Are those tenants employees or affiliated with the company in any way, even if not employee or W2 employees? Do they have an affiliation with your company? Yes. Who lives there? And they give the name. Does he pay rent? Yes, he does. How much does he pay? I'd have to go check. Have you taken any distributions from REBJC since then? No. Not that and it's unintelligible, but it's probably saying it, not that I'm aware of. No. If you have any taken any distribution, do you think you would most likely be aware of it? Yes. So your answer is yes or no. I believe the answer is no. Not to my knowledge. Do you testify that 313 Clubhouse is owned free and clear of the property under LLC? I believe it is. Yes. Does anyone live there? Yes. Is it a tenant? Yes. Do they pay rent? Yes. Is it an employee or someone affiliated with any of the companies we are here to talk about? Some are employees, some are not. Who lives there? There are some of the people that don't necessarily want all their information out there. Does it matter at this point? So then it gives the list of the people, which we're going to skip. Do any of them pay rent? Yes, all of them. How much do they pay? I don't know. Does that money? The real estate companies, man, real estate companies generally know what people wild here. The property that's owned by 3217 Weatherburn, right? Is that a mortgage on that property? No. Does anyone live there? Yes. Are they considered tenants? Yes. Do they pay rent? Yes. Are they affiliated with the company? No. Completely divorced from third parties from this. What are we here to talk about today? Yes. Do they pay rent? Yes. Where does that rent go? To the appropriate LLC. The property owned by 3084 Cobb Parkway. Is there a mortgage on it? No. Is there free and clear? Yes. Do people live there? No. What kind of property is it? It's a vacant lot. So we go through the properties. Each one of these, I'm going to start to move faster here as we move through the properties. Guys, you can read this stuff online, and we're going to wrap this up in just a second here. So have you received a check, a wire transfer, any kind of electronic money for any one of these LLCs, the real estate LLCs? Yes, the ones that I own. And tell me about those payments, please. The rent payments, those come to you directly, not directly. I mean, they come to the company. The RETJ is the real estate company that holds most of those companies you listed. And have you taken any distributions out of RETJ? No. Since August of 2023? No. Have you taken any? Has any payment of any kind, whether you would call it a draw, a transfer payment, or anything a lot, been taken since August of 2023? No, other than maintenance on properties. Your testimony under oath is since August 2023, other than $15,000 that you may have gotten from one of the companies that we are here to talk about today, that nobody has paid for anything for you, and you haven't received any cash, checks, wires, transfer, or any of these companies. Correct. And I'm living off of my savings right now. 6 months approximately. How much longer can you continue to do that? We'll find out. How much do you have in your savings account right now? Do I have to answer that? And to be fair, I don't think so. But she says this is going to go to the credibility of the answers, that no money is being sent out of these companies. I'm going to sustain the objection on how much he has in his personal account, because that is an objection. So the court says, Ms. Evans says, what are your approximate living expenses on a month-to-month basis, Mr. Shed, that you pay for as opposed to what your wife pays for? And I would have to go check, but basically $5,000 a month. How long do you estimate you can go on covering those expenses without any cash infusion? That's is the money she's receiving from the companies that we are here to talk about today sufficient to cover those expenses, whatever they are? I mean, no, the money she receives from the company is very small. What are her other sources of income? She has savings as well. And where does her savings come from? I saved it. And from what? From my years of work. I mean, just over time, I've saved money. How long have you worked? Did you attend college? No, I did not. How long have you worked outside of high school? Approximately 20 years-ish, a little less. Is your wife about the same? A little less. She's a couple years younger. Was there, back on Exhibit 10, the affidavit from Mr. Tadzinski? We walked through transfers 10, 11, and 12. Were there any other transfers discussed in this affidavit that you say did not happen? I believe that's accurate. Then that money ultimately was converted to cash and paid for operating expenses. Is that your testimony? No longer with the company, right? Yes. You can't just say or because she can't type that, as talented as she is. Are there any transfers in any of the other paragraphs that you want to let us know here today that you don't think actually happened? I'm not sure if it's about it, if they happened or not, just the relevancy where they have no relation to us whatsoever. Um, but at the same point, he talks about an over the basically where he just sold some Ethereum over the counter with just a direct Ethereum per dollar transaction. And then he goes and traces the chain for quite some time. And none of that is related to us whatsoever. Where is that? I have to find it. I basically believe he starts around 15 or 16. Basically, all of that onward is just kind of a bunch of nonsense. There's a reference to $143,000, 140 cents in paragraph 15. Correct. Yeah. And we basically, essentially, what that was somebody that needed to buy 90 ETH, and they wired us directly that amount, the dollar value of it, into our account to pay payroll. Are you getting a sense of the deviousness here? So somebody bought the 90 ETH, so they didn't sell it, They wired us directly that amount into our account to pay for payroll. We sent them the Ethereum, and it was an in-kind transaction. Your client knows this. He made a lot of noise about it online, reached out to the other party. The other party confirmed it. And when they traced it beyond that, once he had the Ethereum, what he did with it and where this NFT went, that's all kind of a bunch of noise. It had nothing to do with anything we were talking about today. If you could look back on paragraph 22, do you see where it says 8/18/2023 and it refers to 3455? Do you see that? Is that a reference? Yes. Yes, ma'am. There's a reference to a crypto wallet. I'm not sure. Is it? I'm asking you. I'm not sure. Well, we were just talking. You were telling me that these transfers are a bunch of noise. I think was your testimony. Do you recall that from 15 seconds ago? Yeah, 15. So what do you think 3455 refers to if it's designated in these paragraphs and these transfers as noise? What do you think it is referring to? Actually, what I was saying was noise was everything beyond this, is what I was saying, where they tracked it. What is your question? Do you know what the reference to 3455 is? Well, we'd have to go back. He keeps saying continued examination of 3455. At some point, I assume he alleges in here what it is. I'll withdraw the question. Those are the questions that I have for the witness, Your Honor. Now, we've just finished the testimony of Timothy Shed Jr. at this point. Now, we are going to continue this at a later time. I'm going to come back to you guys tomorrow, and we're going to finish this up with another round of, oh my God, WTF, BBQ, because if you're not entertained and if you don't find this to be absolutely wild, the anger, the rage, the deviousness. By the way, page 113 is what we're on right now. But the deviousness, the everything that's going on here. Nobody knows anything, et cetera, et cetera, et cetera. We're about to get into something that is going to fascinate and amaze you when we get to the rest of this. So, guys, for today, we are done. This is the first part of Ben Armstrong versus Hit Networks and what the results are. So, if you like this type of content, I'm going to be doing another one tomorrow. Hit the like button, subscribe button, the bell to be notified. And, guys, wild. We'll talk to you again very, very soon.